Thank you for being here with us today. And this is the panel on vulnerable accused. So this is actually a panel where we received a lot of questions in advance of the conference. So maybe we're going to start with a question from one of our registrants. And it's actually a recent call who was asking about the fact that many of their clients are racialized women who also endure structural barriers like poverty alongside challenges with mental health. So they're asking for advice about from experienced counsel about this. So Ken, do you want to start and tell us about this?
Sure, and thank you very much both for that and for having me here, Maya. So where I really see the rubber meeting the road with a question like that is where you're in this situation where a vulnerable person is already partway up the ladder. So I don't have a ton of advice or suggestions for a person, a person with no record who's on a Form 9 or such. I think you're in a clear situation of release. But what the question conjures for me is, you have a vulnerable person who is on an own recog or on bail program, and then there's an alleged breach, and then they come back, and I think the most tempting or natural position for the Crown, coming from the Crown's perspective, is to say, well, up the ladder, you need a surety. And whether from time constraints or volume, it's really easy for the Crown to take that view and just try to persuade a justice or JP, up the ladder, you need a surety, without really thinking through the structural challenges that person may face, or more importantly, whether a surety is needed or actually serves the purpose of diminishing concerns on the secondary ground. So, I think I've said to you guys in preparation for today that I've been anxious to get out, and I don't think there's a lot of crowns here, but whether it's advice for my colleagues or advice to counsel and persuading my colleagues, when you're in that situation, a person who's already a step or two up the ladder and is facing that jump to a surety that is going to face some really practical difficulties for them, for my colleagues think about, or for counsel try to persuade on, what are the real specific secondary ground concerns in the case, and can they be met by something other than a surety? So for example, a person with mental health challenges who is underhoused, who is going to have great difficulties finding somebody to say, oh yes, I will put up money and take them on. Well, what are the specific allegations they face? Think in the hypothetical. Underhoused mentally ill person is alleged to have continually broken into his sister's house because he wants somewhere to live or somewhere to sleep. And the third time he's back for that, you're tempted to say he needs a surety. But if we can hear from counsel that, yes, he's had an own bail twice on this, but now, even though I'm asking you for his own bail, we have looked into, arranged, brought together some kind of living arrangement for this person that moves him 10 miles from his sister's house. And we're going to arrange some treatment for him that takes up, 2 days a week of his time, to make it a lot harder for him to find the time to get across the city and break in his sister's door again. Well, maybe that's the tipping point that as a Crown persuades you, there's something in place that gives me comfort that he's not going to break into his sister's house again. So it can be hard work to get into the specifics, but that's what I'm trying to encourage my friends and my colleagues to do, is, resist that temptation of thinking the ladder principle means, oh, he's on for an own recog, he's back on a breach, he needs a surety. Like, get out of that mindset and get into what are the specific secondary ground concerns and how can they be addressed with something other than a surety when this person has no realistic shot at a surety.
Thank you, Ken. And we hope we have Crowns online who are watching, even if they're not here with us in person. I hope they are listening. But then if we move on then, Hussein and Rachel, to a defense perspective, because sometimes it is challenging and there's really no option. I mean, maybe we don't even have apart from sureties. Many of our clients don't have sureties, but also they don't have too many other resources to help them. So what do we do in this type of situation?
I think you're dealing with vulnerable people who don't have sureties. You're going to feel sorry for them, and you're going to want to get a good result for them. Oh, no,
I think you need to turn it on.
This one on.
Yeah.
It's okay. I'm not embarrassed at all. When you're dealing with vulnerable people, you want to do a good job for them. And you have to remember that this is a people business, and people or the law allows enough discretion to all of the players who have discretion, so crowns and judges, to really get to any result they kind of want to in most circumstances. So you have to understand the reason you feel bad for this client is a whole laundry list of reasons that you know about them. So getting back to what Kent said, like when you speak to the Crown Attorney in these situations, like let them know why this person is in the situation that they're in. Like let them know the things about this person's life that make them compassionate, because that's a way to tip the scales. Because all the Crown knows about this person for the most part is like, you're here for the third time in 8 months and you keep doing the same crime. You're not redeeming at all. So remember that it's a people business, and you have to sway people onto your side by letting them know the whole picture. So give that information to the Crown Attorney, because that may make them feel the same way about your client that you do. And they may, like Kent said, look at it again and consider, why they really want to detain this person and look at the big picture. So that would be one of my recommendations. Then obviously, as a defense lawyer, the way I see bail is that you have basically 3 things that you have to do. All of them will be covered in this today. But first is you have to prep the surety. In this case, you don't have one. Second of all, you have to come with a plan that was responsive to the allegations. You can't come with a weak plan of supervision when it's a really serious offense. And third, you have to poke a hole in the case. The reason you have to do that is you get to say to the JP or the judge at the end of the day, hey, we know this person's not going to trial for a year or 2, and it would be a shame if they did that because I'm going to win this case. So that's kind of how you want to approach bail. But in this situation, you don't have a surety, so you're going to have to look for other supports like Ken said. And I think Rachel can let you know that there are supports in the bail system that you can rely on that act as substitutes in some respects for the lack of a surety. We're going to turn them off for the next panel.
Yeah, so I think when you're dealing with someone who's vulnerable, who doesn't have a surety, sort of building on what Ken said, one of the things you want to think about is, okay, let's say I had a surety to propose in this case. What would the expectations really be that that surety would do? And in the absence of a surety, how can we create conditions or connect the client to other services that would essentially do the same thing? So if you would be relying on a surety, for example, to ensure that the client gets mental health supports, you can connect them to a mental health court worker who can prepare a mental health service plan. And that can be a condition of the bail that they work with those supports. If they're eligible for the bail program, you can refer them to the bail program. One of their mandatory conditions is that they take treatment and counseling as directed by the bail program. So that's actually enforceable through the bail in that way. In other cases, we rely on sureties to do things like enforce no contact terms or radius terms. And that can be a little bit more challenging to get through professional supports, but you can think about other ways to do that. Things like putting large boundaries in more serious cases or more persistent cases of breaches. You could consider electronic monitoring, which is free now through the SolGen program. So kind of thinking about creative ways that you can kind of fill those gaps. The other thing I think is really important is to know your client as well as you can, which I know can be a challenge coming at it from a duty counsel perspective. A lot of the time, we haven't met the client before that we're running the bail hearing for. It's often on the same day, but you want to engage with them and hear as much as you can from them about what's going on in their life and to ask them the right questions, particularly where they might be struggling with major mental illness and might have difficulty communicating to you the information that will be helpful for you at their bail hearing, because they might not have a good sense of what's important to you. So you want to ask them questions like, do you have any supports in the community? And, sometimes they might say no. And then you could say, are you on any medications? And they'll tell you yes. And then you can say, well, who prescribes you those medications? Or, where do you access those medications? And by kind of asking a lot of questions, you can sometimes start to piece together that there are some supports in the community. If they're a drug user, you could ask if they've ever been on methadone. And again, if they have, who prescribed it? Where do you access it? So kind of trying to understand what supports are available to them in the community. And then you can either take that information and build it into the bail plan in some way, or just use it to try to persuade the Crown or in submissions to persuade the court that there are services available to address some of the underlying issues that lead to secondary ground concerns. And then the second thing I'd kind of say to build on that is don't be afraid of really considering having your client testify when you're proposing a release on their own recognizance. I do it a lot. My colleagues do it a lot, and it can be very successful. I think there's a misconception that people who are repeatedly in the criminal justice system aren't trying. Or don't care about changing their circumstances or following the law. You'll often hear submissions at bail, like they obviously have no regard for court orders. And sometimes hearing from them as opposed to from counsel about what is actually the reality of their life and that the efforts that they have made to address those issues and the way that they encounter so many barriers every single time they try to do that can be extremely compelling, because you can really sometimes hear from them that they really are trying, and that certain new conditions or new supports that they've been connected to, you really can see that it may actually work. It's not just a case of, well, it didn't work last time, so it won't work this time. Sometimes there's been a change in their circumstances, or they can explain to you why it was a challenge to do things in the past and what their plan is to change that going forward. So I think that obviously it's not an option for every client, and it takes more preparation to ensure that they're going to be able to answer questions from the Crown and to, not say things that are going to get themselves in trouble, but it can really be worthwhile.
Maya, if I can jump in before we
Yes.
move on, actually, just to pile on some agreement to Hussein and Rachel, particularly something Hussein said about, talking to your Crown about your God. And that's, if the task is trying to figure out what's going to persuade your Crown in this kind of situation where this person's on the edge of the ladder, I think Hussein's really correct to point out that as the Crown, we know very little about your client. We know the bad thing they're alleged to have done right now. We know their record, and we know a tiny little bit of biographical information we get from police. So in connecting with us and telling us about him or her, I think is particularly critical. A lot of conversations I have when I'm doing a bail list amount to, pretty please, can he have his own recog again? And that's just not persuasive for a Crown. We need to know about him or her. We need to know, to circle back to my point about the specifics, we need to know how a proposed plan is going to diminish concerns on whatever primary, secondary, whatever happens in that individual case. And I know somebody popped their hand up. The last thing I want to get out is that the other part of context that I'd urge counsel to be aware of is, we're always in a rush. As the Crown, when you've got your list of 20 or 25, 12 of which are new, you're constantly in a rush. So the part of the challenge is to get that Crown out of that mindset of, I want to do anything I can to get out of this conversation as quick as I can and get on to the next one. That's the dynamic that we face a lot in those conversations. So to try to bring the Crown down out of that and focus on, here is this person, here is what's been driving their criminality, here is how what I'm saying can help us with that, even though it's not moving up to a surety.
I just wanted to ask Ken on that point, because I do agree that the more you tell the Crown about the client, the more the Crown can understand the situation and maybe reconsider the release. But the challenge sometimes with bails is, especially if we're dealing with a new client, we don't really know much about them sometimes. So how do we do these types of bails with these clients.
I don't know if I'm the right guy to ask that one.
So maybe,
Because I can say that the more information we have about these people, the
Yeah.
better. But maybe Hussein or Rachel, who deal with more clients than me.
You talk to the family if you can't get to the client, obviously, because a lot of times you're on Zoom and they're at a station or at the courthouse. But talk to the family. A lot of their family members have a lot of insight into these individuals' lives. There may not be a family member, I guess, if there's no surety, but there may be a friend, but you have to get the information. If it's a new client, you're gonna have to find a way to get it. So speed kills in bail hearings. That's the other thing. You're gonna run into situations where your client's like, I need to get out today. I need to get out today. You don't, part of your job as a lawyer is to control what you can control. So you can't control the ultimate outcome, but you can definitely control if the bail hearing's actually prepared. You can, in bail court, you can control your audience sometimes if it's not a good day, for lack of saying more, to run a bail hearing. But control what you can control and tell your client, like, yeah, I can rush this right now and you can get detained and spend the next 2 months in jail before a Myers hearing gets put on a list somewhere before I can bring a bail review, or you can wait over the weekend, right? So control the speed and do what you have to do to put your client in a position where you can get the information to the Crown that might make them feel bad for the client and might make them change their decision. We had a question.
Yeah, we had a couple hands.
Should hand out a prize too.
Okay, does it work? Yeah. This is a question for Ken, but obviously anyone can weigh in. Ken, I wanted to ask, when we're talking about accused who are released by the police, they're not getting legal advice. They're going to accept whatever conditions are placed upon them. And, I heard you say, Crowns aren't necessarily persuaded to go back for release on one's own recog, right? How much is it? And there is research around, overly onerous conditions. How much is it, and, at the forefront of your mind and your colleagues' mind, to whether or not the conditions were that they themselves too onerous to begin with? And, I can give a really simple example, geographical, restrictions for neighborhoods in Toronto. Well, for clients who are vulnerable, who need methadone, that's a tough situation. So I just, I think it's a big problem. And I just want to know whether or not it factors, or whether or not it's, at the forefront of your mind, or whether or not defense counsel are raising these kind of conditions, arguments.
Sure. I think that's a very practical question. And I think the first part is, I didn't mean to advocate that I'm not really open to own recogs. What I'm not open to is own recogs for no reason. And that's the conversation I have a lot, that I'm trying to urge everyone to move past. If your question is, how much as a Crown am I influenced by a release generated by police, whether it's an undertaking to an OIC or another form? Frankly, not much. Maybe this comes with experience, but I wouldn't be particularly swayed that, well, you had conditions A, B, and C on your undertaking to an OIC, so your conditions on your bail must be more. I think, police aren't lawyers. They don't have the same familiarity with the ladder, antic, what have you. So as a Crown with some experience, I don't put a ton of weight on what are the conditions that they crafted. I would have no trouble going down. A junior Crown might feel otherwise, right? They maybe have not as established with the police to say, I don't really care what you think. We're gonna do this other thing. But I would wager, by and large, Crowns wouldn't be too influenced by that. And if you find you're in that situation where you're facing that argument, remind them, well, this person was released at 2:30 in the morning by staff sergeant who's not a lawyer, who really only takes one perspective and isn't bound by the same duties you are. And urge them to think less about that. That doesn't really get into the merits of a geographical or neighborhood restriction on a particular bail, but I don't find what the police craft particularly persuasive in taking my positions, and I'd hope my experienced colleagues wouldn't either.
If I can just add something to that, I think it's also in inappropriate cases, it's absolutely an appropriate argument or sort of line of negotiation to say, okay, well, the reason that that bail wasn't working is perhaps because the conditions weren't crafted in a feasible or realistic way. And a lot of the time, I think we're looking at no contact exceptions, or sorry, conditions without exceptions. We see a lot of clients coming in with no contact with their parents because there may have been, a dispute at the family home, whether it was an assault or a mischief, often low-level offenses. And then there's no contact with your parents who they were formerly living with, no exceptions. And then, you kind of end up with these contact breaches where the complainants are often, not that it excuses it, but a willing participant, at least in, the contact beginning. So it's kind of like, is there maybe a more workable exception, like no contact in person, but they can have contact by phone, or obviously the written revocable consent. So when we see people coming back in on contact breaches, I think it is something that you should turn your mind to is there actually a more workable way of crafting this condition? So we're not just inviting breaches with obviously the parties that need to be protected still being protected.
I wanted to ask you as well, and Rachel, you did talk a bit about this. It's bail supervision programs. And one of the questions that we received is how effective are bail supervision programs?
Well, I think it can be extremely effective. I think particularly for clients who are dealing with major mental illness or substance use issues and really need professional supports. When we look at the option of perhaps having a surety versus the option of having a bail program, the surety might not be someone who's well-versed in assisting someone who's dealing with major mental health problems or serious substance use problems. They might not really know what to do with that. Whereas we know the professionals working at the bail program and the professionals that they have access to through referrals that they make, that's actually their job. And they're extremely good at addressing those issues. So I think you want to look at, again, what's actually going on in the client's life. What do they, need help with? Kind of on what front do they need supervision? And if, as it often is, it's addressing underlying concerns that are leading to the secondary ground concerns, I think bail program can, in certain circumstances, be not only sort of an adequate substitute for a surety, but actually in a better position to assist.
So I agree entirely with Rachel, and not to continue banging the same drum, but what gets persuasive for Crowns is really getting into the specifics of what bail program is offering. When you're on that person who's like just on the bridge to a surety, a vulnerable person, it's very hard to say yes as a Crown to bail program when all we know about bail program is that sheet that says they have to live where bail program says they have to live, and they have to do what bail program says they have to do. When that's all the information we have, that's very difficult to say yes, because that doesn't satisfy us that here are the steps that are being taken to address the secondary grounds or what have you. Well, we're essentially being told, trust us, bail program would do fine. And bail program is great, but what's persuasive to get a yes from us would be have the conversation with bail program. Tell us where this is going, even if it's not written into the conditions in the bail. And I think this actually links to what Hussein was saying before, is that sometimes you have to slow down if that's what it takes to get the information from bail program. If you're worried there's a risk that the person is going to be detained after a run hearing, so you really want to get that yes out of the Crown. Sorry to keep repeating myself.
And there's Diane has a question.
Yeah, thank you. I'm searching for the best way to put it, but essentially in negotiations, we have to deal with the unstated assumptions of both parties. And I find that you have to manage as defense counsel, and want to hear from you as a Crown, what what values the party is ascribing to a form of release, for example, bail programs, sound times, and arguably there is a ranking in the mind of the Crown, and there is a ranking in the mind of defense as to what tools are more effective. And I find that gets in the way. And I think it's related to what Rachel was saying about bail program. And we, as defense counsel, can address and plug holes, but ultimately there is, in the mind of the Crown, it's just part of their list of tools and the way that they think that a surety is always the best, you know, regardless of, it could be a theft under, let's put it that way. A smile will come across the face of a Crown if you proffer a surety, even on a theft under. And I believe that even where we do say, look, sound times is important or useful in this particular case, because the client will not, the client will have specific tools, specific contacts to go to in the case of a drug issue, and that's why it's important. And I'm referring to a specific case. I don't want to talk about all of the details because, of course, in any event, you can draw that out for a Crown and still it'll be a no. And unfortunately, I mean, some Crowns would consent, but I'm just saying it's very difficult to sort of address those biases. However, throw in GPS and you've got it. And I just want to ask of the panelists, how do we get around those unstated bias, even in particular situations where it can be drawn out that this is how to plug the hole? How do we get around those biases? If you understand my question.
I think I do. I think the question was mainly aimed at me. That's I don't mean to keep talking over Rachel and Hussein. So I don't think, I can't spot anything in your question with which I disagree. And I think I don't particularly have a problem with kind of the surety being the magical way to unlock the Crown, if that's available on the practical realities of a particular case. Because while, you know, we can think of the issues that have brought this person before the court, homelessness, mental health problems, what have you, a release that addresses those without a surety is great. But our interest from the Crown, first and foremost, is, you know, what's going to prevent further allegations in the future and what's going to bring this person to the court, and having a person out there in the community responsible for looking over this person on a day-to-day basis. I mean, that's powerful, and that is easy to say yes to. I'm not sure how to say this other than to repeat myself. But like that, getting into, here is a plan that without a surety, so surety's off the table because of practical realities. Getting into, here's the factors that brought this person before the court, and here is how the plan of release addresses those short of a surety: distance, routine, any kind of housing situation, supports for drug addiction or what have you. I mean, I'm hopeful that my colleagues would be open to that. I mean, I can't solve that everybody has their own meter at the end of the day. But I'm hopeful that my colleagues would be open to a plan that says, here are the, you know, as Hussein says, here's what you need to know about my guy. Here's what's brought him before the court. And here is how this proposed plan that I've worked at with bail program, and I know the specifics of, is going to prevent him from coming back. At the end of the day, I can't solve where a particular meter is, but I'm hopeful that my colleagues would be persuaded by that.
I just wanted to add to this vulnerable person situation, especially for the geographical area. Sometimes they don't understand that they can't take the bus to go from point A to point B to either see their mental health worker, or, you know, if they have to go to a clinic for methadone or something. So when you're talking to your client, and the Crown has suggested a geographical area that they can't be in, make sure that they understand that, or that you would let the Crown know that there has to be maybe an exception. Because once that's known, the justice of the peace or the judge in bail court could add that there's an exception to go from point A to point B on the TTC in order to attend a doctor's office or mental health worker or whatever they have to do. Because I find when I'm sitting in bail court, a lot of times, some of these breaches that are from a Form 9 are because they've got on the TTC and to go to a doctor's office. So just make sure that you speak to your client about any type of appointments like that in case that situation comes up.
I think what you're getting from this too is, nobody really wants to be in the no surety situation when, you know, if you had one, all the problems would be solved. So just make sure if you're in that situation, you've exhausted every possible avenue, like make sure there really is nobody. Talk to the family members who the client's saying won't bail me, and maybe you can persuade them that they should come bail them because, you know, this person's going to spend a considerable amount of time in jail, or they're going to plead guilty to something they shouldn't have to plead guilty to, because the bail hearing in many cases is the trial, right?
Just to add to that, I think don't be too quick to rule someone out as a potential surety just because they might not be a perfect surety. And I think particularly where you're dealing with a client where 493.2 A or B applies to them, you know, you want to look at, you know, maybe the surety has a criminal record. Maybe the surety has been a surety before and it wasn't successful. That doesn't mean that they cannot be a surety again. There's very few actual laws about who can be a surety. You know, they just have to be found suitable. So it's really worth talking to them, and you know, often you want to think about issues like, is the criminal record perhaps a result of the over-policing of certain communities, or you know, things like that. The people that this person has available to them might not be people who've never come into contact with the criminal justice system, or, you know, they might not have a lot of options. So it might be the same person again. But if there's a way to structure the bail or to speak with the surety and see if, you know, they might still be a feasible option again, for whatever reason, don't necessarily rule that out.
Thank you. And I wanted to ask you, that's maybe more for Rachel and Hussein. How does getting or not getting bail impact the trial and legal outcomes for the individual?
And for a lot of the smaller stuff, the bail hearing really is the trial. Like the reality is you're not going to get a trial for months and months and months, and the offense isn't worth that, right? So you'll see it. I've seen it throughout the years in Toronto. You'll see some Crown's offices will have their best and most experienced Crowns in bail court. And I've always seen that as just a way to manage the caseload, because if people get detained, that's one less trial that nobody has to have, right? So in many cases, the bail hearing is the trial. So you don't want to mess it up. You don't want to run it too fast. You don't want to put the client in a situation where they can't win. So take your time and prepare it, right? And in those situations too, what you have to be aware of is there are many cases, one of them being White by Justice Casey Hill, that basically says if you're at time served, we can't deny you bail. We have to let you out. So for some of the smaller stuff, if you're in a situation where there's no surety, maybe you wait around so you can make an argument and say, well, the person's already served their sentence. They shouldn't have to plead guilty just because they don't have a surety. Here's the case law, like let them out and let them have their trial. So we recently had a situation like that where the client had no surety and she wanted to plead guilty, but she works with vulnerable people, so she'd be unemployable and she had mental health issues. And we just waited till she was at time served. The Crown wouldn't give her bail. The Crown wanted her to plead guilty. And then we just ran that argument and she got out. And then the Crown, of course, gave me a peace bond after. So they didn't have to plead guilty.
Yes, there's the question over there.
Yeah, I wanted to ask about sort of a different type of vulnerable person, similar to what Rachel was talking about. When you have a client with a significant offense that's going to need sureties, but their sort of whole support network is also involved in the criminal justice system. Their parents have criminal records, their siblings have criminal records, and not minor criminal records. how can you sort of soften the blow when their only options are other people who have had involvement in the criminal justice system?
I think it depends how recent their involvement is, how bad it was, but I've had people get out. Obviously, it's not ideal that your surety has a criminal record, but sometimes if there's a large enough gap, like that's the perfect mentor for the accused, someone who got in trouble, who lived that lifestyle before and has straightened themselves out. So figure out ways to, you have a bad fact, like just like in trials, you have a bad fact, figure out a way to weaponize it. And those might be the arguments that you have. Like, this is a person who lived this themselves, who knows how hard it is to get out of it, but they got out of it. So this is the perfect role model. And they're actually better than someone who's totally clueless about the situation. And the law doesn't say you can't be a surety if you have a record. It just kind of depends on the circumstances. And also like highlight to the justice or highlight to the Crown that this is the only person they have. Like we're not doing this out of a matter of convenience. This is this person's support network, and he has nobody else or she has nobody else. But don't just rule it out because they have a record and they've gotten in trouble before. Sandra?
Hussein, how are you?
Good.
So I heard you mention earlier about not rushing to do the bail hearing. I hear you on that. Several years into my practice, though, I still struggle with the idea of the natural consequences that flow from people being in custody for too long. So think job losses, families being impacted by not having support for kids, that kind of thing, which also leads into 516 issues in Simonelli and all of the stuff that we've learned from our rights to have a bail hearing within 3 days unless your client's consenting to the adjournment. And so I guess the question is, in your practice, how do you balance that really fine line of trying to make sure it's the best plan possible with also trying to respect your client's right to get bail as soon as possible?
Look, all you can do is weigh what's the worst, which outcome is worse. If your boss is going to get mad at you that you haven't been at work for the next day, 10 days, the last 10 days, they're probably going to be a lot more angry if you're not there for the next month or two, right? So you just have to balance out the pros and cons, and it's a difficult decision. If it's, I'm going to lose my job and I'll never get another one if I don't get out by tomorrow, then you have to run it, even though you don't have the ideal plan. But all I'm saying is that make sure if you're not running the ideal plan, because it's your job to put your client in the best position to succeed. If you're not able to do that, make sure that you really, truly are unable to do that, because that is your job. Chris?
Don? Yeah. My question is about this point you've just raised, Hussein, on time served situations and the White case, which also comes up in Myers. In Myers itself, they said one of the reasons for these reviews is to see if the gentleman or lady is in a time served situation, and if so, they should be released. Mechanically, how is it that you'd put that information either before the Crown or the court? And in particular, if the Crown were to say to you something like, well, the position on the brief is covered by settlement privilege, you can't share it with the court, what would your answer be, and how might you try and get that information in front of your JP?
Yeah, so obviously you do get in this situation a lot of times where the Crown's offered you time served, you get into bail court, and all of a sudden the Crown's saying the accused is not at time served. I think if you're overly concerned with settlement privilege, just ask the Crown, listen, do you mind? I'm going to tell the JP that, you've offered him, I'm going to tell the judge you've offered him time served, or the justice you've offered him time served. Can I do that, right? And if the Crown's like sticking to it, just bring your case law, right? And don't be afraid to tell courts, like, go sit into plea court. People get 1 or 2 days for this all the time. People get 20 days for this. Like the Crown's saying this is worth 6 months. Show me a case where someone got 6 months. There isn't one, because they're all unreported, because they're all guilty pleas in bail court that nobody cares about after it's done, right? So be ready to argue if that's the situation, and ask for permission to breach the settlement privilege if that's really what's going on, right?
We have just a few minutes left. There's one question that we received online, and they were asking how many people actually get bail with no conditions, and what are some of the most breached conditions?
My experience is very few get bail with no conditions.
That's my experience.
Like almost, like once you're in bail court, almost nobody. And certainly at least from a Crown perspective, it's IPV contact breaches are what we see more than anything when it comes to breaches, which at least in the context of this discussion, from a Crown perspective, are unfortunately those that are going to most motivate us to aim at a surety, frankly. Because in that context, I have little. Bail program is wonderful. Don't take any of this as a knock on bail program, but they have no ability to make sure that an accused person is not contacting their partner or former partner. So that's a bit unfortunate, but I think that's the reality of the situation from the Crown's view.
And I think what the question may be getting at as well is, are there conditions that are kind of routinely added that shouldn't be there? And I think the answer to that is yes. One of the ones that I really hate is the address reporting, where there's not really primary ground concerns and where a client doesn't have a stable address. It's like, what are we doing? You want them to call every day and tell you that they're back at 129 Peter Street? Like, I don't understand that condition most of the time. So I think that it is worthwhile where you can to challenge including conditions like that. And I think what's interesting is we don't actually see people being breached for those conditions a lot, which is good. But then it's like, why have them there? So, I think it's worth trying to have that conversation with your Crown and litigating those conditions where you can, although I know it's challenging, at least in the environment of the bail center, where now if you want to litigate a condition, you're put on a list of 20 people waiting for a bail hearing. But, it's worth turning your mind to those conditions that are considered by some to be fairly standard about what it's actually addressing in the case. Like if someone's, stolen from the LCBO, why are they reporting their address?
So we have 3 minutes. If there's one last question in the audience, yes, Maya.
Yeah, just on conditions, I'm curious to hear what the panel thinks when your client, where there's a proposal to have a treatment condition as a part of the bail. I'm of the view that JPs and justices shouldn't be ordering treatment for people as a condition of bail. But of course, sometimes those orders will get at secondary ground concerns. So I'm curious to hear what the panel thinks about that.
I mean, sorry.
Go ahead.
It's a fantastic question. I think it's something we struggle with a lot because on the one hand, we want to argue against those conditions. And on the other hand, when that's all you have to propose, that's what you propose. So it's absolutely a bind. And I think sometimes the way I try to approach them is to put in conditions to connect with certain service providers without actually having the condition say, like, take treatment as directed, or, follow the recommendations of your psychiatrist or whatever it is. Like those conditions, I think, go too far, but conditions to go to appointments and to connect with service providers, I think can be appropriate. So that's normally how I try to play it, but I certainly won't pretend that I've never allowed more stringent conditions in, because that is sometimes what gets you the release.
Yeah, I'm not sure how lawful those are in the day when, like, the surety can't tell an accused person, follow my rules at the home. When we got rid of conditions like that, I would defer to Jones J. But I'm not sure how lawful it is to say, go do the treatment that bail program tells you to do, which we still use a lot. Now, so in a contested hearing, I have pretty much stopped asking for stuff like that. But there's no getting around the premise of your question. It can be highly persuasive to getting a consent out of a Crown to say, this person is going to spending their time doing X. So not sure if that answers your question, but I think Rachel had the smartest answer.
No. And so look, sometimes you got to take a condition to get somebody out, and you'll find that it's a lot easier to get a condition removed after the person's already out of jail, shockingly. So sometimes you have to accept a condition you don't like, and then afterwards go to the Crown or bring a review and ask for it to be eliminated.
Thank you so much, everyone. And we're now ready for our next panel.